Hi. So today I'm going to share with you about the evidence that is to be given by the accused in a check bounce case. Generally, when a check bounce case is launched, complainant leads the evidence, and after that, complainant also brings the witnesses whosoever supports the complainant, and then the complainant and the witnesses are cross-examined by the accused. That is the issuer of the check, the drawer of the check, who is generally the accused. And then the evidence of the prosecution or the complainant is closed. Now the court takes the 313 examination, which is called the examination of the accused by the court, because the court can only come to conclusion in a criminal case only after the prosecution or the complainant and the witnesses suffer the cross examination. So now court has material to examine the accused. Based on that material, the accused is examined. That is a 313 examination. That is a court put some questions to the accused based on the charges that are raised against him. And the accused also has adequately cross-examined. The accused has also been given an opportunity to adequately cross-examine the complainant and his witnesses. So the rights are balanced right now. The rights of the complainant and the rights of the accused are balanced. So therefore, accused is examined under 313 Criminal Procedure Code examination. And after examination of 313 examination, the court opens the opportunity, the doors for leading the defense evidence, that is the evidence of the accused. Now the important question that comes is whether accused should lead evidence. If at all accused is leading the evidence, should accused enter the witness box, or the witnesses that are supporting the accused should enter the witness box, is the question that I'm going to answer now. The evidence in a criminal case, in a general criminal case, is always oral. Because somebody kills somebody, there will be an oral evidence. There will be no documentary evidence in a criminal case. The documentary evidence will always be in a civil case. So therefore, the evidence in a criminal case is always oral. But in a check bounce case, it is different. In a check bounce case, the evidence of the complainant is always documentary because it is based on the check and it is based on the bank rejection memo that was issued when the check was presented in the bank. So the evidence of the complainant is always documentary and the evidence of the accused is oral. Please try to understand this point carefully. The evidence of the complainant is documentary and the evidence of the accused is oral in a check bounce case. So based on the scheme of this type of evidence, based on the context of this kind of evidence, whether accused must lead any evidence or not, whether accused must lead any documentary evidence or not. And the answer is that accused must not enter the witness box. This has been also categorically said in section 145 of Negotiable Instruments Act. Now I will share the reasoning why accused must not enter the witness box. Needless to say, in any criminal case, accused must not enter the witness box because the principal test that is conducted by the court in a criminal trial is that the crime must be proved beyond all reasonable doubt. It is not at all the burden of the accused to discharge the crime. It is not at all the burden of the accused to prove that he is innocent. It is the burden, always 100% of the prosecution, to prove that the accused committed the crime beyond all reasonable doubt. Now, what is reasonable doubt means? To the extent of 95%. The complainant or the prosecution has to prove to the extent of 95%. That is the meaning of beyond all reasonable doubt. Unlike in a civil case, the test conducted by the court to prove the case is preponderance of probabilities. There it is 50-50. Whosoever proves 51% will have a case there. But in a criminal trial, because the remedy is punishment here, the result is punishment here, it is 95%. The complainant or the prosecution has to prove their case. So therefore, based on this principle, and why this principle is launched, what is the source of this principle? Now the source of this principle can be traced to the Constitution. Article 23, Article 20, subclause 3 of the Constitution says that no person accused of a crime or of an offense can be compelled to be a witness against himself. No person accused of a crime or an offense can be compelled to be a witness against himself. That is, if a crime is charged or any accused, he shall not be compelled to be a witness against himself. That is, he shall not be compelled to give evidence or to enter witness box to support the crime or not to support the crime. This is the constitutional protection that is given to the accused. This has to be understood, and based on this constitutional protection itself, the rest of the things follow. So, accused must not enter the witness box in a check bounce case. When the Constitution itself is protecting the accused, there is a meaning. There is some inherent meaning in the concept or the scheme under which constitutional mandate was created. So therefore, accused must not enter the witness box. Even the Criminal Procedure Code never says accused must enter the witness box to discharge his crime. Even the Negotiable Instrument Act, check bounce scheme, which is a part of the Negotiable Instrument Act, which is a criminal flavor but basically a civil law, it also never said that. Even 145 subclause 2 says that accused has to file an application to summon the witnesses, but accused should not give any sort of evidence affidavit. But complainant has to give an evidence affidavit. That was clearly stated. But accused must not give any evidence affidavit, and the legislature intendedly, with a great intention, omitted that fact. Now, we must never interpret it in another way. There could be some reason why accused must not enter the witness box, and that is the reason is because of the constitutional protection. Having said that, in a Mandvi cooperative bank case of 2010 of Supreme Court, clearly said the interpretation pertaining to accused not entering the witness box, accused not giving the evidence affidavit, or accused not suffering the cross-examination. There is no need for accused to suffer cross-examination. That is the mandate of the law, which has to be understood and which has to be followed. There could be great reason. Accused has always opportunity to respond to the legal notice, statutory legal notice that is received from the complainant, and give a reply, deny. The remedy that is always available to the accused is to deny the claim, deny the offense. There is no need to put your story. There could be 101 things in interpretation of the scheme of things or the facts. There is no need to go deep into the interpretation of the complainant pertaining to the facts against which the crime is created, the offense is charged with. Just deny it. They will prove it. And you have an adequate opportunity. The accused has an adequate opportunity to cross-examine the complainant and his witnesses to disprove, remember, disprove the story of the complainant and his witnesses. That itself is the opportunity that is to be encashed by the accused. If there is any documentary evidence, generally the documentary evidence is also with the complainant itself. Suppose your complainant gave you money and you are repaying it back. So when complainant gives you money, the agreement will also be retained by the complainant itself. The promissory note, if at all money was given against a promissory note, is also retained with the complainant. Now all sorts of documentary evidence are with the complainant. Now if accused tries to bring some sort of documentary evidence to the court doubts him. So accused has to rebut the presumption of the complainant. Just repel the complainant story with the adequate opportunity of the cross examination. So that itself will discharge the accused. So accused must not enter the witness box, or accused must not give any evidence affidavit. And this was also confirmed by the Honorable Supreme Court in Mandavi Cooperative Bank case. And thank you.